Good morning.
Megan Powell on behalf of Rick McMahon. May it please the court, and I'd like to reserve 2 minutes for rebuttal.
Alrighty.
So we're here today on BMI's appeal of the trial court's denial of BMI's motion for leave to amend to assert a claim for punitive damages. It's important.
I'm gonna just stop you right here because I'm really fascinated by this notion that you can appeal in order denying a motion to amend without prejudice and then still appeal to this court. Because if we affirm, you're just gonna go back and amend, right?
Not necessarily. So
Oh, you can.
you could, that's correct. I think
And why didn't you try to amend before you took this appeal?
so. We're at a point now in the case where the case is nearing the end. It's almost over. Most, if not all, of the discovery has already been taken.
Right.
If we were to amend, there'd be nothing to amend. We'd be submitting the same exact evidence.
So you put forward everything you've got. You're
Yes.
done.
Well, there's other stuff, I suppose, that accompanies this stuff that maybe wasn't attached, but this is like the meat, the most of everything that would have been attached. And we attached everything that we felt was sufficient to get, to meet the pleading standard.
Well, you know, I read the transcript of the hearing and I didn't see any discussion about, I mean, it looked like the judge later entered the order, just hand wrote in without prejudice, not like somebody asked him to do that. But there also wasn't any discussion of, this is all we've got. So if you don't allow us to amend, we don't have anything else to give you.
I don't think that's typical that would be part of the discussion. And I also would just go back to the idea that there's a new rule that allows the appeal of the non-final order.
Right.
And I think ultimately, if you were to require, or if the court were to require that an order dismissing, denying a motion to amend to include punitive damages be with prejudice, it would be nullifying the rule allowing the appeal of a non-final order because
What?
it would,
say that again?
well,
Slow down.
it would be basically violating the new rule allowing the appeal of the non-final order because ultimately that would make it a final order, making it with prejudice.
Well, no, it's still an interlocutory order.
I understand where you're
Still an
coming from.
interlocutory order. And actually, I don't know that the with prejudice language adds anything because any interlocutory order is without prejudice. The trial court at any time can revisit any order that's a non-final order.
I understand. I just
That's
think,
why it's so unusual that this type of appeal was included.
I think it's also unusual. That's what's allowed in the rule now. And I think ultimately because of the way that the rule was drafted and the explicit language of the rule, it's permitted to allow an appeal of this nature. And I think looking at it from the other perspective of whether it was the defendant who was appealing the issue, there is no way that they would get an order with prejudice, for example, if it was granting the motion for leave to amend, if that makes
I
sense.
mean, they're two very different kinds of words, but anyway, go ahead with your argument, because I'm just curious why, you could have just amended, but you appealed. And if we were to affirm, you could still go back and amend.
I
And
understand.
you're not done.
No, and before I move on to my
You
argument,
are.
I'd like to just note, that it's not one of those things where we can ever guarantee getting a dismissal with prejudice either, because the standard for motions for leave to amend is so stringent on the judges that it would be an abuse of discretion to deny with prejudice in most cases. So to require.
I know. But this notion of amending to add punitive damages to me is a little, it probably needs to be approached analytically a little bit differently than amending a complaint to state a cause of action.
I don't disagree.
Because you just gotta allege some elements there, and here you gotta have some facts.
Right.
All right, I'm sorry.
That's okay. I understand. And it is a different.
I am inordinately fascinated by the fact that you can appeal this order.
I completely understand. I've listened to the oral arguments and everything myself, so I have the same fascination.
Right, they weren't thinking about this.
Well, this is where we are.
Yeah,
So going
you're
into,
right, exactly where.
so going into very briefly the history of the case, because Appellee's made the argument that BMI abused the privilege to amend in the underlying case, or the court may have denied it for that reason.
This is the last time I'm going to
Sure.
interrupt you, but I don't see that because
Right.
he wrote in without prejudice, and it's the only time he sought to amend to add punitive damages. Any other amendments were to the actual causes of action in your various counts of your complaint. So I'm not seeing that, but
They took the words right out of my mouth. I was just gonna say there were no findings of prejudice or of any sanction or anything saying that it was an abused privilege. And it was also only the actual second amended complaint of the new action after the settlement. So this case was brought in 2007 by BMI, and in 2010 it was actually settled. And and that settlement was designed to facilitate BMI's use of the commercial units that it owned at Regatta at the beach club. Those units he wanted to use to run a restaurant, a spa, etc. The settlement basically had non-monetary and monetary provisions, and those non-monetary concessions were to facilitate guest parking, not interfering with guests' ability to use the space, etc. After the settlement, BMI brought.
I am correct, the monetary provisions are satisfied, that's correct.
Yes, that's correct. So obviously the 2011 case for enforcement of the settlement after BMI alleged that Regatta violated the settlement was consolidated with this action, and here we are. So the standard is obviously de novo on this issue, and the pleading standard below that the trial court would have had to consider was to look at all the pleadings, the evidence proffered, and the record evidence identified to determine if plaintiff made a reasonable showing that there's a reasonable basis for recovery of punitive damages. I agree with Your Honor that there isn't a kind of a fact component here, but it is still a pleading standard as well. So,
well, yeah.
yeah,
No,
So-
I think I agree with you on that.
right. So there's two types of cases in which you can seek punitive damages per the statute. There's gross negligence and intentional misconduct.
Right, and we're intentional misconduct.
Yes, Your Honor. So the evidence, the best way to illustrate the sufficiency of BMI's evidence is to look at two cases that, in my opinion, on one side and the other, are illustrative of what was sufficient and what wasn't sufficient. So the first case I wanted to go through was Sun International Bahamas versus Wagner. Now that's a case where the court found that there was sufficient facts to uphold the punitive damages award, a little bit different standard, but just bear with me on the facts here. This is a hotel that contracted with a model to allow that model pictures to be used in hotel advertisements for 3 years. After the 3 years were up, they wanted to continue using the model's photographs, but they didn't want to pay the model again for a new contract. So they just used them anyway. The model sued them and later asked for punitive damages. The court found that just the fact that the hotel knew before they used the photographs that what they were doing was illegal, it was sufficient to support the award for punitive damages. And this was even though the hotel attempted to later withdraw the advertisements that had the photographs to limit the exposure of the model. So looking at a contrasting case out of this court, we have Porter versus Wilson, in which a doctor had an investor who the doctor agreed to pay a portion of his revenues in an MRI business in exchange for the investment. He later opened up a second location thinking that what he was doing was okay. And he even asked his attorney if it was okay. And the attorney said, yeah, it's fine. The investor sued him because it necessarily reduced the value of the original business and asked for punitive damages. And in that case, the court found it important that the doctor actually didn't mean to do something wrong. He did break the law. He broke the contract, but he didn't mean to, and he asked his attorney. So everything that he did was in good faith. So these are the two contrasting cases for intentional misconduct I wanted to highlight. So going into BMI's specific evidence, did you have a question?
No, go ahead.
Okay.
Go ahead.
Going into BMI's specific evidence, there were several documents. So there was the motion for leave to amend, which attached the Fifth Amended complaint. The Fifth Amended complaint had the allegations pleading basically the idea that underlies BMI's punitive damages claims, which is that BMI was induced to enter into the settlement. Regatta purposely breached the settlement with the intent that BMI be put out of business, and then that BMI would be foreclosed on because it couldn't pay its dues. Later, BMI was foreclosed on, and Regatta actually purchased that foreclosure judgment. Now, to support this, like I said, there's the motion for leave to amend with the Fifth Amended complaint. There's a total of 14 attachments to that document with the Fifth Amended complaint attachments and the motion. The motion for leave to amend also identified the motion to transfer a memorandum in support, which was earlier and was filed in the record and was argued previously in the case because there's another case that's sort of related to this one that's pending. That was ultimately denied, but that was identified with its exhibits as supportive records. Then we have the reply to Regatta's response, which included additional proffered evidence. Now, Apelli has made the argument that the memo in support was not adequately identified. I can address that if the court likes, but I also believe and submitted in the initial brief that even the evidence attached to the motion for leave to amend and the reply are sufficient by themselves.
Let me just ask you a question. It is what it takes, not every count of your complaint seeks punitive damages. I think like the breach of contract, and I can't remember. There's like maybe three or four.
A few,
counts.
yeah, not all of them.
But what would it be a correct characterization of your position to say that what takes this out of an ordinary, bad business behavior type litigation is that the association undertook these alleged actions for the purpose of getting your client out of there, putting them out of business and getting them out of there and making their ownership, they own, correct?
Or they
Of
did,
these
yes.
commercial units worthless.
That's certainly a huge part of it. And the second part of that is that they did it despite a trial court order upholding several of the non-monetary concessions in the settlement agreement.
So in other words, once the trial court upheld, or they continued to ignore the trial court's order.
Yes, and even before the trial court, before the challenge on the settlement, they already decided they weren't going to abide by the settlement. So normally what happens if you have a settlement and then it's valid until proven invalid. So it should be abided by until it's invalidated. So they didn't even abide by it before it was invalidated, and after they chose to continue breaching the settlement agreement and doing everything that they could.
But many of the things that were invalid, I understand what all the areas, you would have needed the approval of your unit.
Yes, and those are not relevant to this case because that's where there was a previous appeal in this case where the trial court dismissed with prejudice our client's claims because some of the breach claims were based on those invalidated terms of the settlement agreement. And so the case that we have now are only the causes of action that this court held to be valid. So it's not really relevant to this, but yes, that was a decision. And I guess it is relevant to the extent that they promised to do these things and also to hold an owner vote. And then these things ended up there was no owner vote, and then these things ended up being invalidated. So there is pre-settlement action as well that goes to the intent of Regatta. But
Refresh my memory that the BMI purchased these commercial units from the developer.
yes,
Is that correct?
to my memory, yes.
And then almost from day one, the association didn't want them in there. The association thought that the association should own those units.
My understanding is that the association wanted to own those units and then
And
BMI purchased.
and they just set on a course, we're gonna do everything we can to get you out of here.
That's certainly what the evidence we submitted, I think.
Well, I mean, that
for
articulating
demonstrates.
your position.
Yeah.
So that's right?
Yes,
your
that's
position?
correct.
So I'm gonna go back to my question, because I want you to say it in your own words instead of me trying to say it for you. I'd like to know specifically what conduct you allege takes this out of just the garden variety business tort level and moves it into punitive damages. I know one thing you said is they're ignoring a court order.
Yes, and so I actually have the testimony that we submitted in support. There's first the testimony of John Bass, who was the 2010 president of the board, who in quotes said, quote, "We settled the lawsuit in 2010. New 2011 board comes in and says, hey, listen, we're not going to fulfill our end of the settlement agreement. So, hey, we're going to pick and choose things that we're not going to agree to."
So that's bad faith
Right,
in the settlement.
And
And your position is that bad faith?
before and after. Yeah, so before the settlement and after, but there's more. So there's
Is he speculating what happened
no, this is his opinion, because he's on the board of directors,
on the board?
not anymore,
Not
no,
on the board,
but this is deposition testimony.
it's just his opinion.
Yes. Yeah, and he articulated in his depo that he was going based off of his opinion.
But that's not factual.
It's not factual, but you can use lay people's opinions as evidence under Florida law, and this would be his testimony at trial, and that was his.
He's a stranger to what the new board did.
Well, he's talking about what occurred while he was involved with the board of directors. So this is contemporaneous with his leadership on the board of directors. And there's at this time, he's not. He was president at the time that the stuff he's testifying.
He did, he was president. I just want to make sure I'm clear. He's offering an opinion as to what the new board was doing and was intending.
Yes, but I believe he was still involved with that board, the 2011 board. He was there for these discussions and this. So this is stuff that he witnessed and that he would be testifying to at trial. But I do also have the testimony of a 2017 board president, Dorinda Bachman, who was definitely involved with all of this stuff, who said that she. Oh, and one of the main commercial units in contention was the restaurant unit, CU2. And Dorinda Bachman testified that the goal, as she interpreted, was that they would control that unit for a profit, or all of his commercial units. Then she testified that the board wished to use that space, the CU2 space, to open a private club for public membership. That you could have based on a membership basis, which is interesting because they were wanting to prevent BMI from bringing in patrons from the public, but they wanted to open up a public club. Then we have.
I guess where I'm sorry, I'm interrupting you
That's okay.
again, but I guess where I'm stuck is, and there's often, so many of the cases we see really bad behavior or alleged bad behavior. I'm not making any judgments, but for the sake of argument, really bad behavior that people in commercial relationships can engage in, but they're, not every case is a punitive damage case.
I agree.
I'm trying to understand. I understand what your allegations are, but is it their motivation to drive BMI out of business that's really the linchpin of your punitive damages argument? And if you take that, like if you couldn't, let's say you couldn't establish that was their motive, but they engaged in all this bad behavior, would you still assert that this is a punitive damage case?
I believe yes, because ultimately it's about the injury, and he did, whether it was their motive or not, he did lose the units due to not being able to use them, and their goal was that he wasn't able to even make any money off of them because they were blocking him at every avenue from using the units. And I think it goes back to this being a pleading standard. The questions you're asking me, I understand why you're asking them, but they're questions for the jury ultimately to decide. This is whether there's a reasonable basis for punitive damages. And I think the evidence presented does demonstrate, or at least tend to show, the intent of the association to put Mr. Hoffman out of business. And if I may, there was
So really, the intent to put him out of business is really it really is the linchpin. Is that
Yes.
fair to say that's what takes this case to a different level?
I just think it's a combination of three main things. You've got the disregard of the court order upholding the settlement and not doing the things that they agreed to under the settlement even after it's been validated. You have the intent constantly from the start to put Mr. Hoffman out, or BMI rather, Eric Hoffman is the owner, out of business because they wanted these units for themselves. And then there's the ultimate purchasing of the units in foreclosure, which I think goes as well to not a confirmation, but evidence suggesting that the intent is there and that the motive was that the whole time.
Well,
So
they
it's-
may have gone foreclosure for reasons unrelated to what the daughters did. I don't know what their relationship is with their lenders or what brought about the foreclosure.
I understand where the court is coming from. I just think it's about what the evidence that was submitted tends to show. And then it would be up to the jury to decide whether that was something that was as a result of Regatta's actions or whether it was a result of some other external factor. And I think ultimately Regatta's purchase of the units goes more towards the intent than just the foreclosure itself. But ultimately, we have to look at the statements of the board of directors throughout this entire thing. They're telling us their intent the entire time, under oath a lot of the time. They didn't want to honor the settlement because that would mean Eric would still own the commercial units, especially commercial unit 2, the restaurant unit. The restaurant unit is significant because a member of the board actually told the guy who was going to lease the restaurant, Tim Brill, that they were going to basically not honor the settlement, challenge the settlement in court, which you can challenge a settlement, but she said, we're going to set Eric straight and that any attempts to use the restaurant in the meantime would be blocked. This is before a challenge to the settlement. So they're knowing that they're assuming this is a valid settlement at that point because it hasn't been invalidated. And they're saying we're not going to allow the things we've expressly agreed to allow. And Mr. Brill, in his affidavit, stated he was willing, ready, and capable of making the investment and opening a restaurant there. And all they needed was to continue forward with the board's approval. And he was driven away.
You've got 2 minutes.
Oh, thank you. So I just want to wrap up quickly so I can leave myself just a little bit of time for rebuttal. I think comparing the evidence that was submitted in support of punitive damages to the cases I referenced earlier, Sun and Porter, there's no doubt that there was at least substantial evidence provided suggesting Regatta's intentional misconduct here. And I think it should have been left up to the jury to decide whether that was something that should be assessed or not. Thank you.
Morning, Your Honor. May it please the court. Elaine Walter from Lloyd Richards Parker Colonelli, representing Regatta Beach Condo Association. I'm trying something new. I'm using my computer. I hope I don't mess it up.
You're braver than
I'm trying. I kind of want to start where you started, Judge Kelly, with the argument about whether you have jurisdiction. I'm not sure that the rule amendment was well advised, but it happened.
Right, it says what it says.
And as far as coming from the perspective of an appellate practitioner, a non-final order is always non-final until there's a final order,
Right,
and therefore can be reconsidered anytime. Therefore, by its nature, it's without prejudice.
right,
So I think we're just stuck with what the Florida Supreme Court decided for us.
I know. Can you tell I don't like it?
Well, the Rules Committee didn't either.
No, they did not, did they?
So I, just wanted to put that out
Yeah,
there.
no, I
before I
was like, as I said, I was inordinately fascinated by the fact that they did that. And here we are.
Yep, okay, let me get to my notes real quick. I was looking at the appendix. Okay. So what I want to do, we have two basic arguments Regatta on this appeal. And the first one is that the evidence offered in support of the motion for leave to amend for punitive damages just didn't get there to support. It wasn't reasonable proper to support the leave to amend. The second argument is the trial court didn't abuse its expression in not permitting leave to amend based on the fact that there had been 3 other attempts for leave to amend. Judge Kelly.
Well, I'm back to what I said before. I'm seeing that argument because when he wrote out that order, he put without prejudice, which to me doesn't say you can't try again. It says, yeah, try again if you want. So I'm not understanding where you're coming from in saying that they couldn't amend again.
And to be honest, I think the without prejudice probably puts a knock in my argument. But I am relying on the Rodriguez case out of the 3rd DCA that says, even if you submit motions for leave to amend and don't have them heard, they can still be considered on whether you have abused the privilege. But again, I do have to agree with you that the judge did say without
Yeah,
prejudice.
and you have to acknowledge, right? This is their first attempt to assert a claim for punitive damages.
Absolutely,
So
absolutely.
they haven't really abused their privilege of trying to say punitive damages. Maybe you consider the number of attempts they made to state their other claim.
I think what our position is that they had most of this information that they're relying on years before they tried to assert a claim for punitive damages. So why wasn't it done earlier? Why was it pushed so far down the road?
Okay.
So I think that is our basic premise as to why the leave to amend privilege could have been one basis. But I also understand that without prejudice sort of cuts into that.
Okay. All right.
So as far as the evidence, I'm going to start where my opposing counsel left off with the major evidence that she noted for whether or not there should be punitive damages. And that was 2 depositions of prior presidents of the association. One was Mr. Bast and one was Miss Bachman, and I'm sure I just brutalized her name and I feel bad for that.
It's okay.
But what I want to do is talk about what they really testified about and the quality of their testimony. And I want to look at Mr. Bast first. And he said, do you think any of the board members wanted to put Rick McMahon out of business? He said, prior to my board or after? Both, please. Before your board, absolutely without a doubt, that's the 2010 board that did the settlement agreement. After your board, I don't know, is what he said. That's his testimony about what the board was trying to do. So again, anything is speculative or opinion and not necessarily evidence that would support punitive damages.
So you say he said before 2010, they absolutely did?
Yep, he did. Now,
Well, you know, part of one of the things that's been a focus of their argument is this entering into a settlement agreement and then disregarding it and then disobeying a court order. So, at least with respect to, you entered into this settlement and the court has now told you that certain provisions are valid and enforceable and you still ignore them. You don't consider that misconduct?
I think
Intentional misconduct?
I have two arguments
Okay.
on that. The first one, Your Honor, is that as this court ruled and as the trial court found, and your opinion came out in, I think, August of 2017, that there were some ultra vires acts taken by Mr. Bast, the person who made this testimony, because he approved personally the settlement agreement without getting a 75%.
Right, but some of it was enforceable.
Correct. I agree with that. But that, I think the testimony, in the Tim Brill affidavit that came from one of the board of directors, Audrey Cornu, she said, we're going to challenge it. She was providing him the information that we are going to challenge it. We don't think we have to follow it because it's not enforceable.
Okay, but after this was litigated and the court enforced part of it and they continued to say, we're not going to abide by this, even the part that the court has upheld.
I understand that, but those particular provisions were also still on appeal before this court. All of the conduct that we're arguing about at this point,
So
we're
you can
discussing.
ignore a court order if it's, as long as it's on appeal?
Not necessarily, Your Honor. There probably should have been some sort of stay. But most of the activity was done that we're looking at was done prior to when that court order came down. There are a couple of them that are not. I can speak to them. One was the removal of some guests of BMI from one of the units. And I think that happened in 2014. And that was done because the board thought it should, well, a member of the board, I don't want to say the board, I don't want to attribute to the entire board, that because of the lawsuit, people probably shouldn't have been in the restaurant and they were asked to leave. One of the other ones, most of the other ones that I have looked at, and I can take through them if you would like me to, people not getting key fob or not getting stickers or key fobs getting access. Mr. Hoffman, the owner of BMI specifically, that testimony in the record was prior to 2010. That was by one of the managers. It was during the deposition taken in 2009. And there's a reason why it's important, and I will tell you that. As far as trespass that was found, that was also, I believe, in 2007. So there were events that happened before that court order was actually entered. We're also talking about not necessarily board action, but a few people, a handful of people who maybe had would like to get that those spaces for the association, but even that conduct doesn't seem to be punitive damages worthy.
Well, I keep making myself read the definition because this is in the context of a business litigation. This is really a hard concept for me to apply, but intentional misconduct means the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursue that course of conduct resulting in injury or damage. And that really seems to fit. I understand that you look at what they've submitted and you're like, it's not that bad and we can explain, but it seems like that's what the jury does, is decide that. It seems to me that what they've laid out fits within that definition.
Yeah,
Like, we want to drive you out of business and we don't care what the court says. And we don't care what this other board did. we are gonna do it. We're gonna litigate this. We're gonna make your life miserable. We're gonna stalk your patrons. We're gonna do everything we can to drive you out of here. So their goal is to inflict damage, and they did do it. So why shouldn't a jury get to decide whether your argument, your characterization of their conduct is the more persuasive characterization?
I think it's borne out by the fact that the facts are interpretations of the facts to some extent. And so Dorinda Fatchman, who was one of the presidents, and she was on the board for 4 or 5 years after the 2012 order came down. And she was asked in her deposition, did you ever hear anything from anyone on the board about how they wanted to acquire the property? No, and there's a list of questions. Did you hear that anyone not on the board was trying to get the property? No, no one ever said that to me. Has anyone on the board ever indicated that they wanted to put Brick McMahon out of business? I never heard anyone say that. So it goes on. There's a list of questions, and this is at pages 547. I'm sorry, 534 through 535 of the appendix submitted by the appellee. Some of the other evidence that we're looking at, those are the main ones that the appellant looked at. But some of the other evidence that they say merits punitive damages really doesn't. There's very little. The only thing that they're using to say that that Regatta didn't fix their units is photos of the units where they had damage, and a list, an email, and a list of things that
Well,
were
let me
fixed.
ask you, in looking at whether they presented a reasonable basis, should we look at each action in isolation, like for instance, oh, they didn't repair this unit, or is it more a course of conduct that they set out upon with the goal of driving them out of business?
I think you can look at the totality. I don't think you have to look at the individual items, but a lot of the individual items that they're alleging aren't supported. They're not admissible evidence. And that's a problem with the proffer, because for the court to have entered an order granting, the judge would have had to listed what the admissible evidence was as the basis for punitive damages. As far as there being a course of conduct by the board, by Regatta, that's not really evident. There are a few people who may have said, hey, I'd really like to get that unit. Hey, I don't really like that being here. It seems to be not, I don't want it, but there's no real dig in, let me figure out a way in this evidence. There's no dig in, let me figure out a way to put this man out of business.
Okay.
Or this business out of business.
Yeah, I understand.
Yeah, there's testimony, everybody actually really liked the man, so individually. So I know you've read the records, so I don't want to regale you with what all the evidence is, but it is our position that most of that evidence just doesn't tie itself to actual punitive damages, intentional conduct by the board or any member of the board. It definitely was not ruled on by the board. I also do want to point out, because one of the cases that opposing counsel relied on is the Porter case, where it was medical equipment and a sale of a business. And in that case, they relied on the advice of counsel, and that court found that because there was advice of counsel, that they'd done their due diligence. And within both Ms. Bachman and Mr. Bass's deposition, they say the board or individuals on the board were relying on the advice of a counsel named Michael.
Yeah, they
Broadway.
for that occasion.
Yes, so, I guess where it comes right down to it, our position, Regatta's position, is that there just is not enough damages or not enough information, facts on the record that are actually supported that should permit a claim for punitive damages, and we would ask the court to affirm.
Okay,
And if there are any more questions, I'm happy to answer them.
thank you.
Okay, thank you. For brief rebuttal.
Probably should have done it on my computer too. So I just wanted to touch on a couple of things that opposing counsel said. I think the issue with Regatta's argument is that most of their arguments as to the sufficiency of the evidence talk about the weight and credibility of the evidence and the perception of how that evidence is different in their perspective to in BMI's perspective. And respectfully, I just think that's a trier of fact question and not so much to meet the standard. I would also say that the act of one board member is an act of the board, and the act of one board member every year, a different board member, or, you know, every year is not quite accurate, but multiple times a different board member equates to the act of the entire board. And then before the settlement, it's not as important, but it is still relevant. The action of the board to enter into the settlement and do these non-monetary concessions, it was obviously important to Regatta or to BMI to be able to use these units and then to go directly against what they've agreed to in the settlement and prevent the use of these units. Even with advice of counsel, you've got a court order upholding a settlement. You've now challenged it to the extent you could challenge it, and it's been upheld. So you're at a point now where it's not reasonable to continue to disallow him to use the commercial units. And then as to the Bachman testimony, the testimony that opposing counsel read is from the same deposition that Ms. Bachman testified that the goal that she interpreted was that the association would control the units for their own benefit, that they wanted ownership of the commercial space, and that they didn't want BMI to own CU2, the restaurant, because they wanted to use it as a club. So I think that argument also goes to the weight and credibility of Ms. Bachman's testimony and what the jury would decide given those two inconsistencies in her testimony. And then lastly, I think the court should look at the totality and that the evidence was supposed to paint a picture. So every piece of evidence, I think in my brief and my reply brief, I set forth why I think the evidence was admissible, most of it at least. So I think looking at a totality of the evidence, I don't believe that the court was correct in denying the motion for leave to amend.
Thank you both. All right, we are going to take a quick break and we will return to conclude the last three cases on our docket.
All rise. We are recessed for 10 minutes.
I'll leave that out.